Thank you, Chairman. Judge Jackson, good to be with you again.
Good to be with you.
I know that a great many people are extremely proud that you are here today. I don't know that there are a great many who are prouder than Bruce Selya. And so, with your permission, I'll take a moment and offer into the record some of his comments about you, and then maybe give you a chance to reciprocate with a word about him. But yesterday in my opening remarks, I mentioned the Boston Globe article in which Judge Selya said that about you, she is absolutely everything you would want in a Supreme Court justice. She has all the tickets in terms of her intelligence, her education, her work experience, and her demonstrated judicial temperament. I see some of the same qualities in her that I saw in Ruth Bader Ginsburg: humility, the ability to inspire others in a quiet way, not at the top of her voice. Some people have the capacity to inspire by example and the force of their reason. Intellectually, she is very smart, very well informed, and she is very hardworking and focused. She gets the big picture. May I ask unanimous consent that the Globe article be admitted into the record?
Without objection.
But he didn't stop there, Your Honor. He went on to WPRI, a local station in Rhode Island, and said about you, she's worked hard. She deserves it. And I literally don't think that the president could have made a better choice. I think she'll be a terrific addition to the Supreme Court. She listens to what other people have to say, but makes up her own mind. She has a very scholarly approach toward the law. She has a very winning personality. She's kind to the people she comes in contact with, and she has a certain humility that I find very attractive in people. May I ask unanimous consent that the statement from WPRI be put into the record?
Without objection.
Judge Selya went on Law 360 and said, I sense that she has the same sort of desire to achieve consensus and a pragmatic streak that has characterized some of Justice Breyer's work. I think she will be quite balanced. I have not found her to be an ideologue. She understands what the job of being a judge or being a justice is. She wants very much to do it in the right way, and she will bend her considerable talents to that direction and won't get distracted by any extraneous considerations or side issues. I think the country will appreciate that, and will appreciate that this is a woman who understands the importance of the position and will give 100% of her talents every day to do that job in the right way and in accordance with her oath of office. Unanimous consent that that be put into the record?
Without
Chairman?
objection.
And then finally, the Providence Journal, our home state newspaper, Katie Mulvaney, in an interview, heard Judge Selya say, I think it's a terrific appointment. She's a very thoughtful person and wonderfully well qualified. I'm happy not only for her, but for the whole country. She listens well, she gets the whole picture, has great respect for the rule of law. I think she's got the whole package. Unanimous consent that that article be put in the record.
Without objection.
So, any reflections on Judge Selya?
Oh, well, that was very moving. Thank you, Senator, for reading his lovely remarks. It's exactly who I know Judge Selya to be, always eloquent, always insightful, and I'm so flattered by his admiration, because he is someone that I have admired my entire professional life. He taught me how to look at issues very carefully, how to write in a lot of ways because of the way in which he's so fastidious with his opinions. And he's been an extraordinary mentor and role model for me.
Well, we are very proud of him in Rhode Island. As you know, he's on senior status, and when he went on senior status, we were able to recommend the Rosary Thompson to succeed him, of whom I think Rhode Islanders are equally proud, and she has now gone on senior status. And Mr. Chairman, I hope we'll be considering shortly an equally impressive Biden nominee for her position. On an unrelated subject, and it relates to yesterday's activities, you can relax a moment, Your Honor. This will not be a question for you, but a lot was said in this room yesterday about dark money by our Republican friends, to the point where one of the headlines about yesterday read, "Republicans hammer dark money groups." And I'll be the first to concede that there is dark money on both sides, and I hope very much we can get rid of it on both sides shortly by legislation. But there is a difference, I believe, between a dark money interest rooting for someone and right-wing dark money interests having a role in actually picking the last 3 Supreme Court justices. Now, how do we know that they had a role in doing that? Well, we know because everybody involved said so. It was pretty straightforward stuff. President Trump said we're going to have great judges, conservative, all picked by the Federalist Society. That's pretty plain. Senator Orrin Hatch, former chairman, was asked, some have accused President Trump of outsourcing his judicial selection process to the Federalist Society. I say, damn right. The co-founder of the Federalist Society said that the administration is relying on the Federalist Society to come up with qualified nominees. And then Don McGahn, who ran the operation for Trump in the White House, said, "I've been a member of the Federalist Society since law school, still am, so frankly, it seems like that role has been insourced." So there's pretty clear and pretty broad agreement that that selection process took place out of the public eye, and it appears to have been informed heavily by dark money interests. They were not alone in saying this. Here's Laura Ingraham on Fox News, concerned about abortion cases coming up before the court. "We have 6 Republican appointees on this court. After all the money that's been raised, the Federalist Society, all these big fat cat dinners, if this court with 6 justices cannot do the right thing, then I think it's time to circumscribe the jurisdiction of this court. That's the way to change things finally." So we have people who are in a position to know what was going on behind the scenes describing the 6 Republican appointees on the court who got there after all the money that has been raised, the Federalist Society, and all these big fat cat dinners, and threatening that if they don't do what she considers to be the right thing, they'll be punished by circumscribing the jurisdiction of the court. That's pretty big talk, but it's backed up by pretty big dollars. If you go back to before this enterprise got underway, the money that came into the Federalist Society from what's called Donors Trust, which has been described as the dark money ATM of the right, a Koch brothers affiliated operation. Back, say, in 2002, it got $5,000. No big deal. By 2019, when this operation was in full swing, it got $7 million. We don't know who the real donor was because that's the job of Donors Trust, is to de-identify the donor, to launder the identity off the donation so you can't connect the dots any longer. But $7 million, I think, is quite a lot of money. And unfortunately, the Federalist Society was not alone. Right down the hallway is something called the Judicial Crisis Network. Its office is on the same hallway as the Federalist Society in the downtown Washington building, although JCN's website and tax filings list a mailing address at a different location, an address shared by multiple companies. And right down that hallway at that Judicial Crisis Network, there's even more money pouring. And here's how much poured into the last 3 nominations via the Judicial Crisis Network. $21 million related in time to the Gorsuch nomination, $17 million to the Kavanaugh nomination, $14 million to the Barrett nomination. And of course, we don't know who the actual donor is. Could be the same donor, who knows? And because we don't know who the donor is, we don't know what business they might have had before the court. And I think it matters when people are seeking to influence the makeup of the court, that the public understand what business they may have before the court. And anonymity hides all of that. And they didn't stop with the Trump nominees. They got up on the air, a dark money group using dark money to accuse Biden's Supreme Court nominee, at that point a player to be named later. Judge Jackson had not been selected at this point, of being a tool or stooge of liberal activist dark money. This is a screenshot from their advertisement paid for by the Judicial Crisis Network. So it's worth understanding for a moment what the Judicial Crisis Network is and where it lies. And it lies in a network of organizations. The prevailing way that political mischief is accomplished these days is with a paired 501c3 and 501c4 organization. The 501c3 gets the tax deduction, the 501c4 gets to participate in political activity. And sure enough, there's an 85 fund and a Concord fund that are twinned together as a 501c3 and 501c4 organization. And they filed under Virginia corporation law to operate under what they call fictitious names. That's the term of law under which they file, fictitious names. And there's the Judicial Crisis Network, one of the fictitious names of the Concord Fund. It has a parallel judicial education project that is a fictitious name of the 85 Fund. If you're interested in voter suppression, you can move down to the Honest Elections Project Action, another fictitious name, and its 501c3 twin, the Honest Elections Project. And they've even got new ones that are less active, Free to Learn Action and Free to Learn. So these are 8 organizations that are essentially one organization. As lawyers, we think from time to time about piercing the corporate veil. That's corporate veiling that you could pierce with a banana. And it runs back and forth with 3 groups called CRC Advisors, CRC Strategies, and CRC Public Relations that take and send money to these organizations as part of the sort of planning element. You might say that CRC Advisors, CRC Strategies, and CRC Public Relations, this trio, is the command center, and this is the operational torso of the creature. So I show this all because it shows considerable effort when somebody goes to that much trouble to create that many organizations to hide how much money they've spent to control the nomination process to the court. And it's no small amount of money. In the original Washington Post research, they pegged it at $250 million. Further research led to testimony in my court subcommittee that the number was actually $400 million. And we have a recent report that we haven't fact-checked that the number is actually even higher than that. So I may amend this number upward once we're done with our fact-checking. $400 million funding conservative activists' behind-the-scenes campaign to remake the nation's courts. That operation is a very different thing than a group rooting for somebody. And I want to make sure that that difference is clear, since our friends on the Republican side have made dark money such a big focus of their attention already. There is a drastic difference between rooting for somebody and controlling the turnstile that decides who gets on the court, controlling the funding of the political campaigns that pursue the folks on the court. And actually, once you get on the court, we're working now with the judiciary itself to try to clean up the mess of that same anonymous money appearing before the court through phony front groups that file amicus briefs in little flotillas, or if it's an important enough case, in a full armada of dark money funded front groups. So that bears not at all on this nominee, but because this is a very public forum and because we've heard all that so-called hammering of dark money groups, I wanted to make sure that it was clear to everybody how this game is played and what the difference is in the way the two sides play it. So now, back to our business, Judge Jackson. You have served as a trial court judge.
I have.
You have served as an appellate court judge.
I have.
And with any luck, you are on your way to serve as a Supreme Court justice. Now, one of the things that is very different about trial court judges and appellate court judges is what their role is with respect to fact-finding. It's my belief from my time spent as a practicing lawyer that the role of fact-finding belongs at the trial court level. That's where you can look the witnesses in the eye. That's where the evidence can be amassed. That's where the trial judge has the responsibility of sifting through it. If there's a jury, then the jury, of course, is the ultimate fact finder. But if you're in a non-jury trial, the trial judge is the fact finder. Then the case goes up on appeal, and it comes up with a record of fact in the case. And in my view, that record of fact that comes up to the appellate court is actually a constraint on the power of the appellate court to go wandering off. The court is obliged to consider the appeal based on the factual record that was adduced in the district court. So you, having lived in both of those houses, the trial court house and the appellate court house, tell me a little bit about what that change meant to you as you went from being a trial judge to an appellate judge.
Thank you, Senator. It is a really big difference. As you mentioned, at the trial court, you are on the ground level. Parties have filed the case. You have all of the issues usually at the trial level because you'll have the complaint if it's a civil case, and there'll be a lot of litigation about the development of the facts in the case. In civil cases, you have a period of discovery in many cases that is really about the development of the record, what actually happened in this case. Sometimes there's even a trial, and that too is a part of the development of the facts in the case because a jury will be charged with the responsibility of determining what happened, who's guilty, for example, if it's a criminal case, or who's liable, if any, if it's a civil case. And sometimes there are even questions presented to the jury that they have to determine the facts. At the appellate level, as you said, there is already a record, and the court is looking primarily at the law, the legal principles that guided the decision below based on the factual record. And importantly, at the appellate level, there are standards of review that the Court of Appeals applies when it decides how to review whether or not to reverse or affirm the judgment of the lower court. And I've been very mindful, especially as a trial judge, of the standards of review.
When I was prepping lawyers for oral argument before appellate courts, I would often say, please don't quarrel with the facts unless you have a knockdown case, because if you want to get the appellate court to relitigate the facts, you're up against the harshest standard of review available, the clearly erroneousness test. And clear error is no small thing. Outside of that narrow finding by an appellate court that somehow the district court got it wrong, filtered through that clear error standard, are there other circumstances in which it's proper for appellate courts to do their own independent fact-finding outside of the record of the case that they're reviewing?
I am not aware of any. There may be, but in my experience, the fact-finding is done at the trial level. The Court of Appeals only looks at facts under standards like clear error. And so therefore, the record is usually set and established by the time you get to the Court of Appeals.
Yeah. And I think that it's actually one of the constraints on the judiciary that they don't get to go and do free-range fact-finding. They have to be tethered to the record of the actual case before them. It's related to the case or controversy requirement.
That is correct, Senator.
And in that regard, civil juries are, I think, something that Americans have prided themselves on for a long time. You go back to the colonial days, and the civil jury was one of the immediate imports from England. Every colony set up civil juries. When the Crown tried to interfere with the civil juries in the colonies, it became casus belli for the Revolution. It was in the Declaration of Independence of what the king had done wrong that offended the colonists and caused the Revolution. And the documents around the founding and around the creation of the Constitution all reflect passionate belief in the importance of the jury, including the civil jury, which, as you may know from your experience in the trial court, is getting to be a rarer and rarer creature. And in fact, there are trial judges who have written about how do we keep the civil jury alive? And I'd like to hear your thoughts about whether there's more to the civil jury than just a fact-finding appendage of the trial judge, whether it was seen by the founders and whether it belongs in our constitutional structure as a part of the responsible self-governance that was established by our Constitution.
Yes, Senator. It is part of our ordered liberty. It is a mechanism by which citizens can participate in governance. They can be called upon by the court to sit in judgment of other people in the community. And it was something that was a part of the democratic vision of the founders from the very beginning.
Blackstone was one of the legal experts who the early lawyers of the United States relied on. I suppose there were lawyers who had nothing but Blackstone's commentaries and the Bible on their shelf. And Blackstone described the jury as having a role to make sure that the power and clout of big and powerful interests could be protected against, that it was a refuge from the power of what he called the more powerful and wealthy citizens. There was long experience in government of corruption, whether it was getting to a chief executive and getting them to do things your way for improper reasons, or whether it was controlling a legislature, a legislative body. But the jury is fundamentally different because they don't stick around. They're there for one case and one case only, and then they disappear. You can't fix them so that they decide your way over time. And if in that one case you try to fix them, you've likely committed a criminal offense. Tampering with the jury is a pretty significant thing, is it not?
It is.
If anybody tampered with a jury of yours, how would you respond?
Oh, very seriously.
So the jury lives in a protected environment from a lot of the political power and the danger of corruption that the elected branches often suffer. And do you have thoughts about the importance of the civil jury in that regard? as the bastion where people can go, where they'll get a square deal from regular citizens and can stand toe-to-toe with the lawyers for however big or mighty an opponent they may have, with almost no danger, let's put it that way, little danger, lessened danger of the fix being put in.
Well, certainly the jury system is designed in that manner, that citizens are brought in from the community. When we pick juries, we ask as judges, do any of you in this pool have any connection to anyone? You know,
So you screen them for conflicts of interest.
you screen them heavily. That's part of the, what we call the voir dire, the sort of,
We don't do that with people who come to Congress.
well, in the court
They
system.
come with their conflicts of interest, often right on their lapels, sometimes hidden in their back pockets. But juries, not so, correct?
Not so. And in fact, that would be a reason to exclude someone from the jury. And we even ask, you know, do any of you, as judges, we say, do any of you know me? And if you do, you'll have to let me know and be removed. Because the idea, as you've indicated, is to get people from the community who have no connection to the case and can hear the evidence that's presented in the courtroom and the arguments of the lawyers and make a decision that is unconnected to any sort of personal interest they might have.
Protecting the jury against the dangers of bias or corruption, giving the parties before it a clean and fair shot.
Yes, Senator.
So, with any luck, you will be on the Supreme Court before long, and I hope you will remember all of this, because it seems to me that the court has been on something of a campaign to deprecate and diminish the civil jury, including by allowing big corporations to build into their standard contracts, buried way down in the fine print that folks often don't read, and even if they do read it, they'll never get through the phone tree to find somebody to complain about it, try to strike it out of the contract. It's a take it or leave it adhesion proposition. And they build into that you've given up your right to a jury. Your Seventh Amendment right to a civil jury. It's right actually in the Bill of Rights. And I cannot think of another right that the court pays less attention to or throws more readily under the bus. If you read the mandatory arbitration cases, there's rarely a mention of the Seventh Amendment. And it seems to me that it flies in the face of the purpose of the jury to allow the citizens of the greatest power and wealth, who are today corporate citizens, to actually be able to take on the ability on their own through contracts that the customer has no chance to negotiate. The employee has no chance to negotiate, to actually take away that right that was at the heart of our founding without a squeak of objection or even notice by the court. And I think it's created a dramatic shift in power towards big corporations. And I think it has harmed innumerable employees and customers. So I am extremely happy that you have been able to answer these questions with such clarity about the role and the history and the value of the civil jury and its importance, not just as your fact-finding adjunct, but as an important part of our constitutional structure, part of our structured liberty as Americans. I wish you well. I'll see you again tomorrow. And thanks so much for your patience with all of us here today.
Thanks, Senator Whitehouse. And let me just say a positive word to follow up. This committee, in the last few weeks, has passed legislation signed into law by President Biden, which in cases of sexual harassment, provide that individuals who are complaining have the option of a jury trial, despite efforts to steer them into mandatory arbitration. It is the decision of the complainant, the venue that they will seek. I think that is a step in the right direction, and we've passed out of this committee on a bipartisan basis.